This is The Law Show on CL 650. Now back to the show.
Hello, Judge Walton, let us on that beat go. Hello, Judge Walton, you're our court of last resort. Our lives are up against the wall, won't get on TV.
The song is The People's Court. That's by the guy that did The Streak. That's why it threw me off. There's Ray Stevens. This is The Law Show. I'm Sterling Fox. John Lakes and John White are the partners that form Lakes White LLP, a North Vancouver estate planning law firm dealing specifically with wills and estates. John Lakes does most of the work and the office. John White spends a lot of time in court. So, John, let me start with you, the court guy, because this is where a lot of it comes out. This is the stuff we see about in the papers as much as anything else. What's the big fight about? We're going to get back. John Lakes was talking about the importance of a will. The importance of a will, I should think, aside from one's personal peace of mind, would be to avoid the kind of fights that you participate in regularly. So what do most people fight about the most?
The most? Well, one of the big fights is something that you can only prepare for so much, and that is the person who thinks that they should have received more in the will than they actually do, or the person perhaps who's been cut out of the will entirely, and they want to vary the will. British Columbia has a law which you don't see in other provinces, which permit a small group of people, spouses and children, to apply to court to essentially complain that the will did not make just, equitable, and adequate provision for them, didn't leave them enough, didn't treat them fairly. And the court has the power and the discretion to vary or change the will to give the disappointed beneficiary more of the estate than he or she actually got in the will.
Is BC the only province, John, in which this can happen?
BC is the only place where we do that.
Really?
But it's been around in this province for almost 100 years. The whole idea was so that children typically, or spouses, wouldn't get cut out of the will and become a drain on the state, wouldn't be put onto the public purse.
Right, okay.
That was the original idea. But we've evolved since then. And now the concern is to make sure that spouses and children are at least given a reasonable shake. It doesn't mean that you have to treat everybody equally, and it doesn't mean you can't disinherit somebody and have that stand up if you have reasons to do so.
Right.
But there is at least that opening that exists for spouses and children to challenge a will, and we spend a lot of time in court fighting on those issues.
Okay, and a variation is simply a change.
A change.
Right, okay. Permission to change, please, Your Honor.
Exactly.
And how often does it actually happen that the courts go, yeah, that's fair, let's change that?
Now, it depends on the facts, of course. I mean, the courts, as I said earlier, don't have to make sure that everybody receives the same amount of the estate. All it has to make sure is that there's been just, adequate, and equitable provision for each of these people who are within that group of people who can actually challenge a will.
Right.
So a court can look at an estate, look at a history of a will, look at a history of a family, and conclude that, you know what, Johnny didn't get the same amount as Jimmy or Billy, but it's within, what Johnny got is within the realm of what's just, adequate, and equitable, so we're not going to change the will, even though Billy and Jimmy got twice as much as Johnny did.
Does, when the judges take a look at these reasons that one brother got more than the other, or that one sister was completely cut out and the other one who was the caregiver in later years gets it all, when these changes are made, I would assume the intention of the letter of the will maker is taken into consideration. And this, John Lakes, is I'm coming back to you, and again, I've watched too many legal TV shows, but when it comes to reading the will, the clerk in the scene always starts off with, well, I, John Smith, being of sound mind and body, and that's how the thing begins, which indicates a certain degree of mental competence. So when we're talking about these changes in open court, does the judge go back to the reasons the person was cut out or only got half and try to interpret the frame of mind that went into that reason?
Well, the problem is there has to be reasons, and how do you give reasons? So some wills I've actually put in provision. So a couple times I've had somebody who's got one child who's very successful financially, and that child says, "Mom, don't include me." So I'll put a provision in the will, say, "I love all of my children equally. However, Johnny has said to me that I don't want anything,
Right.
so I'm going to leave $10,000 at Red Cross," and that's a positive thing. I might do a declaration as to the reasons why. Like it may be that one child was lent $200,000 and the other child wasn't.
Mm-hmm.
And hopefully, if we do a declaration, that's sufficient evidence, because, of course, the person who wants to change one child's inheritance won't be there. But also, as a lawyer, I have an obligation to keep good notes, because the problem is I would end up being a witness to any trial.
Right.
And I have to make sure that I've given them.
Also, if you were challenged at trial, if that provision that you had written
Yeah.
in was challenged, you might be called to say, well, why did you write it in that particular fashion?
Well, that's right. And then I might have what's called a covering letter to say, "I've explained this to you and you're aware of the risk and you've decided to proceed this way."
Okay.
And there's other things you can do in planning, like naming inheritance for life insurance and so forth. But, a lot of times there's a problem too, because like there was a case not a few years ago in which a will was set aside because somebody came from a different country where they left more assets to boys and girls, and the judge said that
So you
was,
get these cultural differences, right?
But you may also have.
And do the judges overrule that? Do they
Well,
say,
you
well,
see-
that may be great in the old country, but in Canada,
Well,
everybody's treated
The
equally?
problem with WESA or these challenges is at the end is the decision of the judge. And you could have two cases with one case with almost exactly the same facts, and the judge may make different decisions because it's at the discretion of the court.
Right, right.
But the problem is, a lawyer doing a will, you have to help that person if that's how they really want to do. You want to make sure you have evidence that's admissible if it is challenged in the future. So, but sometimes I find the problem with a lot of people is when their children might have a mental health issue or an undiagnosed issue where they're a very difficult person to deal with.
Right.
And so, and also it's very hard in a will, because sometimes if a child's been not treated the same as everybody else, and their parents died, so they can't go back to the parents saying, "Why did you do this to me?" And sometimes you're dealing with people's emotions, and like your will, again, as I said before, is your last message to the world. So if you're going to not treat your children the same, sometimes your reasons are perfectly valid. You make sure there's evidence. So if you've already given your son $300,000 for a house and you're just trying to even things out, that's probably a legitimate reason. But if you're getting to reasons for marriage or sexual orientation or religion, that's usually not really that acceptable.
Okay. These matters where, just to follow up on what your partner was talking about here, John White, when a family is from another part of the world in which male children are decidedly treated differently than female. There is more advantage to being male. And so an estate comes up, and the daughters don't receive as much in the will as the sons, because that's the way we do it in the old country. Can the daughters in Canada now challenge that, going, why? Why wouldn't we have not? In Canadian law, we would be recognized equally. This is Canada. He died in Canada. Can we not get some restitution here?
Well, they can challenge it, but let's not forget that the parents or the will makers, assuming they're the parents, don't have an obligation to treat all the beneficiaries equally.
Okay.
They may have reasons for treating beneficiaries unequally that we don't like here in Canada and we don't do anymore. But there is still the ability of the will maker to treat people unequally.
Okay.
And these wills variation cases are so often a real dance between what did the will maker intend to do,
Right.
and whether what the will maker actually did basically passes legal muster, whether what they did provides appropriate provision for typically spouses and children. And quite often, when the courts decide not to vary a will, they'll focus on the fact that it's pretty clear what the will maker intended to do, and they'll cite the whole idea of what we call, or basically just letting the will maker make the decision as to what they want to do with their assets. So there's, as I say, there's no obligation to make sure that all of your children inherit equally. And even if you have bad reasons for doing that, that doesn't necessarily mean that a court's going to set them aside. If they are completely crazy reasons, that might be a bit different.
Okay. There's one word that's come up in this conversation several times, and that's executor. The role of the executor in all of this is something that we're going to examine when we return after this quick timeout here on The Law Show on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.